Voice 9 from the Courtroom Voices series from AAA Insolvency. The main issue today is the judgment in the case of Ram Kishore Arora versus Bank of Maharashtra. This judgment is from NCLAT. This was the Ram Kishore Arora is the promoter of Supertech Group of Companies, and this particular case is regarding the Section 7 application has been admitted in the case of Supertech Realtors Private Limited. This was filed by Bank of Maharashtra. Bank of Maharashtra was also a member of the consortium, and this corporate insolvency resolution process has been initiated despite that there was a settlement proposal going on between the company and the consortium, where the other banks, including the Bank of Maharashtra, was also a member. Now, this judgment is dated 3rd July 2024. It is from National Company Law Appellate Tribunal, Principal Bench, New Delhi. The applicant, Mr. Ram Kishore Arora, who is the promoter of Supertech Group, and this company, Supertech Realtors Private Limited, belongs to Supertech Group. Respondents are Bank of Maharashtra, and the case is that on 12th of June 2024, this case, Supertech Realtors Private Limited, was admitted under Section 7 of IBC, and the CIRP started. The IRP was appointed. In fact, the corporate debtor defaulted long back in March 2022. A joint lender meetings also took place on 18th March 24 to discuss a settlement proposal received on 13th March 24. Now, in this case, the applicant, the promoter of the company, argues that the corporate debtor acknowledged the debt and default. There is no dispute about it. The proposal for settlement of dues was submitted to the consortium of lenders led by Union Bank of India, where the consortium is also having Bank of Maharashtra as part. The Kotak Advisors Limited proposed to invest via an ARC, offering 75% of the running ledger book balance of all the banks. The lead bank agreed to discuss the proposal, but the Bank of Maharashtra sought additional time to consult their head office in their joint lenders meeting. Now, the project, which is Supernova project, which is about 80% complete, and it would benefit from the funds to be provided by Kotak Advisors for its completion. Now, the respondents, like the Bank of Maharashtra, argued that the company had also brought in various OTS proposals, and those have not been honored by the company or the promoters. The OTS proposal was discussed in the joint lender meeting, and it was the application under Section 7 was also submitted before that. In fact, Bank of Maharashtra said that there was another application submitted by Union Bank of India for initiating CIRP of the company under Section 7. Now, because of this application, the Union Bank of India application also became infructuous. So, the initiating CIRP, it was necessary, and as the debt was defaulted, the IRP was appointed. Now, the legal issues involved in this particular case, according to NCLAT, that whether the CIRP should be initiated despite the corporate debtor's proposal for settlement being under consideration by the consortium of lenders. Now, the Section 7 application, the NCLAT says that the consortium of the banks, they should have waited for some time to seek the proposal through Kotak Advisors Limited. They were offering 75%. The court further ordered that in this case, the CIRP would not move further, the committee of creditors should not be constituted, the ongoing project, which is Supernova, may continue under the supervision of IRP. Now, with the cooperation from the corporate debtor, of course, the bank accounts of the corporate debtor will be operated between the IRP and the corporate debtor for the construction purposes. Now, the next hearing in this case is scheduled for 8th August 2024, and the NCLAT thought that by that time there may be a final proposal from Kotak advisors, and that may be considerable. So therefore, this kind of time has been given by NCLAT to the promoters of Supertech Group. Now, the interim directions given by NCLAT that the IRP will manage the company, the constitution of the committee would not happen, and the project would be continued. Now, the one that this judgment highlights that that although two applications were pending before the NCLT under Section 7, so the promoters in fact took the advantage of this settlement proposal. According to the lenders, these kind of proposals were also coming earlier. No final decision was taken. Union Bank of India also had submitted an application under Section 7, and Bank of Maharashtra had also submitted an application under Section 7. Now, this approach of giving an additional time to promoters to pursue the settlement, that is what is the proposal, which is the route that NCLAT has taken. Now, in a normal typical cases, the IRP would function, IRP would receive claims, IRP would constitute committee, but in this case, it was the entire process was stayed. Now, the only apprehension is that the other promoters also may kind of start using this judgment in their favor to either delay the process or to stay the process. On the other hand, the lenders, they should also be very careful that if they have one proposal pending, they should reject that proposal or they should accept that proposal before the insolvency can be started or the insolvency can be pursued. Now, the COC constitution is prohibited. The claims, of course, are coming. IRP is functioning. Now, the project as such, I'm hopeful that in 1 month time, maybe some good proposal will come, or in the next hearing, the promoters will come along with some proposal which is being discussed. So this kind of judgment, one, it actually can promote the promoters to come and apply for all kind of initiation of CIRPs, and in the meantime, the lenders can also learn that they should close and they should take final decisions what route they want to adopt, whether it will be OTS, settlement, or insolvency. Thank you very much.